Hey there, y'all. We are going to be in section 1D, press access to criminal justice process. So we will talk about four cases. The first is going to be Shepard v. Maxwell in 1966. The second will be Nebraska Press Association v. Stewart in 1976. The third, Richmond Newspapers v. Virginia in 1980. And the fourth, Hochins v. KQED in 1978. Okay, so let's jump into the first one. Shepard v. Maxwell in 1966. The case has an 8-1 reversal of the lower court decision, and Justice Clark writes for the majority. So, what is the context? Basically, the question is, Shepard is this guy who purportedly murdered his wife, allegedly murdered his wife. And they want to know, was he deprived of his due process in his conviction trial due to the extreme coverage of the trial and the case? So his wife was pregnant at the time when she was murdered in the upstairs bedroom of their house. Shepard was basically assumed to have killed his wife by the police and the coroners and was questioned while he was drugged in the hospital. Shepard was extremely cooperative and did not request a lawyer. Shepard was subpoenaed by the coroner once in private and then was subpoenaed again in public with hundreds of observers, people from the public, news, radio stations. They even had it like live broadcast. A subpoena where they interviewed this guy for 5 hours in front of the public in a high school gym. He asked for a change of venue and said, look, this is crazy. I need to get somewhere where there's not as much publicity, and they refused. The jurors were not sequestered, as jurors generally are, and they were not told to avoid the news and journalism related to the trial. And even the juror information, like addresses and names, were published by the local newspapers. So the decision by the court is that Shepard was not given, quote, the judicial serenity and calm to which he was entitled. The media should never have been allowed inside of the bar. So, you know, when you're in court and there's sort of the witness, not the witnesses, where the public sits, and then there's that big bar with a swinging door, and then the lawyers and the jury and the judge sit in front of the bar, right? In this case, they let like 30 journalists inside the bar. And they set up tables inside the bar, and apparently it was crazy. There were distractions all the time. There were people yelling and shouting. There were photos being taken all the time. People coming in and out of the courtroom. And so they say, you know, the Supreme Court said that's absurd. That should never have happened. And that the court disagreed that the lower court judge couldn't hold journalists accountable for their behavior. They could have held them in contempt, right? And that it should never have gotten that far. And so basically they say Shepard must either be released immediately or retried within a reasonable time, because the journalism around the case was just absolutely wild, and the judge did not fulfill his duty to keep the courtroom calm. Okay, case 2, Nebraska Press Association versus Stewart in 1976. The court votes unanimously 9-0 to reverse the lower court decision, and Chief Justice Berger delivers the opinion. So, in 1975, 6 people are found dead in a home in Sutherland, Nebraska's tiny little town, and basically the entire family is murdered. Erwin Simons is listed as the suspect and is immediately caught that night. A reporting prohibition was issued by the courts But then the Nebraska Supreme Court sort of altered it and said that newspapers are blocked from publishing three things, right? Number one, the existence or nature of any confession or admission made by the defendant to law enforcement. Number two, any confession or admission made to a third party except a member of the press. And then number three, any other facts, quote, strongly implicative of the accused. So once the jury was selected, the press restrictions were ended and the journalists could write whatever they want. But Simons argued that this makes the case moot, right? That they shouldn't have been able to write that stuff. Why? The court basically disagrees wholeheartedly, unanimously. Why do they disagree? They say, first, the press is way too important when weighed against the rights of the accused. The public interest for local reporting is just too great, right? Furthermore, stopping reporting would basically end it, leading to censorship, which can't be appealed, whereas an unfair trial does have processes for appeal. And so the court rules that even the less restrictive Nebraska State Supreme Court ruling about journalism couldn't be enforced and was unconstitutional. Those three rules that I talked about earlier. And finally, that the term strongly implicative could not be used again and was unconstitutionally vague, right? So they say, in all, this guy, Erwin Simons, he will stay in prison. His guilty verdict will not be overturned just because newspapers published information about his case, and that the state cannot step in and try and restrict that newspaper information. Okay, case 3, Richmond Newspapers v. Virginia in 1980. The vote is a 7-1 reversal of the lower court decision, and Chief Justice Berger presents the majority. So, what is the context? The question here is the right of the press and the public to attend trials guaranteed by the Constitution? This man named Stevenson was found guilty of murdering a hotel owner in 1975. He stabbed him to death. The Virginia courts overturned the decision due to some impropriety in the evidence and set a retrial. Stevenson was retried. The jury hung. He was retried again. This is the third trial. The jury hung again. Another trial is scheduled, a fourth. In the fourth trial, the judge decides to make the trial private. No one objects, not the prosecutor, not the defense. Stevenson was found not guilty, and he was released. Journalists pressed the issue, though. Even though the case is sort of moot and it's already been over, journalists pressed the issue and said, we wanted access to the trial. We think we have a right to watch the trial. And they basically said there are, why should trials be open to the public? The courts say there's an Anglo-Saxon tradition, first of all, an historical tradition that gives assurance to the public that trials are free and fair, that discourages perjury and misconduct in the courtroom. It discourages decisions based on impartiality or bias when the public can be involved and watch. And it provides what they call a communal prophylactic against communal violence. It allows for some sense of justice and grieving, whereas if the trial were not open, the community doesn't get that sense, right? And they rule basically that the right to attend a trial is implicit in the First Amendment. Okay, the final case, case 4, Hutchins v. KQED in 1978. The court reverses the lower court ruling in a 4-3 decision, very close. And again, Chief Justice Berger presents the majority opinion. So, the question is, do news organizations have a constitutional right of access to county jails and prisons? Hutchins is a sheriff of Alameda County, California, and the jail. and he runs the jail basically, and he decides who gets access to the jail. A prisoner committed suicide in the Alameda County Jail, and KQED, which was a local reporting outfit, wanted access to the jail, and Hutchins refused. KQED and the NAACP, the National Association for the Advancement of Colored People, filed a suit under the First Amendment, quote, by refusing to permit media access and failing to provide any effective means by which the public could be informed of the condition in the facility or learning of the prisoner's grievances, right? Hutchins, however, cited Pell versus Percunier in 1974, which states, quote, newsmen have no constitutional right to access to prisoners or their inmates beyond that afforded to the general public. The district court and the appeals court both ruled that journalists have a First and 14th Amendment right to access prisons and jails, but the Supreme Court rejects that and says, no, we rule and we defer to the stare decisis, or the precedent of the Pell decision. Why? First, the courts don't have the power to adjudicate this decision. They say that it needs to be left up to the legislatures as to whether media outlets have access or not. Second, other forms of oversight exist, according to them, including citizen task forces, prison visitation committees, grand juries, prosecutors, judges, and others. And that this also extends to hospitals and mental institutions. So journalists do not have a special right of access. All right. That is the final case in this section, and we will have one final section in this unit. Have a great day.